Hello, everyone. My name is Manish Agarwal. I'm an arbitration practitioner and a partner in the London office of Three Crowns. On behalf of the firm and the Mumbai Center for International Arbitration, I'm delighted to welcome you to the inaugural India Climate Change and Environmental Disputes Day. The context of our discussions today, anthropogenic climate change, is one of the most important issues facing our global community. It is indeed of critical importance to India, and it is therefore appropriate that we are convening today on the Human Rights Day. We will hear more about these and related themes in what I'm sure will be a deeply insightful discussion amongst our esteemed speakers, to whom I also convey my gratitude. As for our agenda for today, we will start with some opening remarks from my partner, my guru, Constantine Partasides QC, who's a founding partner of the firm and one of the leading lights in the field of arbitration. We will then move to a panel discussion, which will be moderated by my colleague, Nicola Peart, a senior associate in our Washington, D.C. office, who has expertise in international climate change law and who recently served on the ICC's task force dealing with such disputes. And finally, we will conclude with some closing remarks from Niti Sachdeva, the Secretary General and Registrar of the MCIA, whom, as you know, has played a pioneering role in the development of institutional arbitration in India. Nicola will introduce our panelists in due course, but now, without further ado, I will hand over to Constantine.
Thank you, Manish. It's a great pleasure to appear on this panel. Good morning, good afternoon, ladies and gentlemen. 2 weeks ago, Glasgow hosted an international climate change summit of unprecedented scale. 40,000 attendees, 197 states represented, and an extraordinary range of participants from civil society, intergovernmental organizations, trade, industry, and of course the private sector. In the opening words of the Executive Secretary of the United Nations Framework Convention on Climate Change, the UNFCCC, Patricia Espinosa, climate change, she told us, is about much more than environment. It is about peace, stability, and the institutions we have built to promote the well-being of all. This, I should say, is not hyperbole, ladies and gentlemen, because 1 month prior to the Glasgow summit, the world's most authoritative body on climate change science, the Intergovernmental Panel on Climate Change, or IPCC, released its latest findings on the physical science basis of climate change. The results are now beyond any serious scientific dispute. Global warming is now a present reality. The consequences are already severe, and they extend beyond rising sea levels, extreme weather events, and the degradation of ecosystems and food chains, to economic consequences as well. Earlier this year, Swiss Re published a report finding that future unabated climate change could reduce global economic output by as much as $23 trillion. That's more than 10% by 2050. In a worst case scenario, countries like India may see their GDP drop by up to 1/3 by that date. So we are now beyond debating the balance to be struck between environmental safety on the one hand and economic well-being on the other. The two manifestly go hand in hand. An environmental economic revolution is needed. And in truth, ladies and gentlemen, it has already begun, and a reliable and efficient system of international dispute resolution, particularly arbitration, has a very important role to play in helping to ensure that this revolution is a successful one. Let me focus on India, and let me offer you only two statistics. There are indeed many more that I could. India estimates a need for over $200 billion of investment in the coming years to implement adaptation actions in agriculture, forestry, fisheries infrastructure, water resources, and ecosystems protections. That is macroeconomic investment by any measure. India is now the second largest emerging green bonds market, with more than $10 billion in issuance so far, most of which has been used to find and attract foreign investment in renewable energy projects. As I said, there are many more such statistics that show the order of magnitude of the environmental economic revolution that countries such as India will face in the years to come. But this scale of investment needs a functioning system of international dispute resolution. And so I turn to arbitration. The transition to a new energy economy will be accompanied, of course, by a proliferation of new legal relationships between states, financial institutions, corporates, and individuals. These will be enshrined in new contracts, new laws, and new treaties. And these new relationships and new legal instruments will lead, of course, to new disputes. And as the international dispute resolution mechanism of choice in recent years, we can expect arbitration to perform an essential function in the resolution of these new disputes. Indeed, that new wave of cases, in truth, has already begun. Let me offer you a few examples of which I'm aware. And let me begin with some examples that we at Three Crowns have seen firsthand. We as a firm have acted for a company in a contractual dispute involving the supply of components for the development of wind turbines in the last few months. We have acted for a state in a contractual dispute concerning the failed development of waste treatment facilities that were intended to generate carbon credits over the last year. One of my partners has sat as arbitrator in a complex commercial dispute concerning the construction of the largest solar power plant in the US, the first of many such disputes. And we are seeing a large number of oil and gas project decommissioning disputes that arise all over the world when those oil and gas projects reach the end of their life cycles and require safe, environmentally friendly abandonment, reuse, repurposing, or recycling. So many private contractual disputes of a variety of types arising because of the onset of this environmental economic revolution. But let me move from pure private contractual disputes to disputes that we can anticipate involving sovereigns under treaties. Earlier this year, many of you will be aware that two German coal companies launched separate claims under the Energy Charter Treaty against the Netherlands over its phase out of coal power as part of its climate change legislation. Assuming the respective tribunals in those cases find that they have jurisdiction, a central issue in those cases will be whether the Dutch government was required to compensate those coal companies for the impairment caused to their investments by the government's transitions to a low carbon energy mix. Also this year, and prominently, a Canadian energy company, TC Energy, launched a $15 billion claim against the United States over the latter's cancellation of its permit for the Keystone Pipeline project, which had faced political criticism that the intended use of the pipeline would be incompatible with the US government's climate change objectives. And over the last 10 years, multiple arbitrations have been launched by renewable companies seeking to recover losses incurred as a result of changes to the policies introduced in recent years by EU member states to attract and incentivize foreign investment in renewable power. Our own firm has been involved in a number of those cases against both the Spanish and the Bulgarian governments. And similarly, in a NAFTA claim launched last year, a US conglomerate, Koch Industries, commenced arbitration proceedings against Canada over that government's decision to cancel an emissions trading program, thereby instantly devaluing Koch's investments in carbon credits. Now, among others, there are two themes common to this new wave of investment treaty cases. The first is where the balance lies in international law between protecting and therefore incentivizing foreign investment, while at the same time granting states the regulatory space needed to address climate change. The second related theme is who bears the cost of the global action to address climate change. Now, these are the themes that we expect are likely to play out in a large number of both contractual and investor state arbitrations in the years to come. So the global response to climate change is already fertile ground for new disputes, and those disputes will likely only proliferate in future. Arbitration is already a valuable and effective mechanism for resolving those disputes, and this will in turn, ladies and gentlemen, facilitate the scale and scope of public-private investment that is needed to meet the therapeutic goals that the climate crisis now undoubtedly imposes upon us. Adapting, therefore, the words of Patricia Espinosa, the Executive Secretary of the UNFCCC that I quoted previously, as our new environmental economic revolution now gathers pace, international arbitration is going to be one of the key institutions that will play an important role in promoting the peace, stability, and well-being of all. So this, our seminar today with our friends in Mumbai, is a timely one, an important one, and like the rest of you, I look forward to hearing what other panelists have to say about it. Thank you.
Thank you, Constantine, for providing that valuable context and background, and welcome to all of those in the audience to this panel discussion today. As Manish mentioned, my name is Nicola Peart. I'm a Senior Associate at Three Crowns in Washington, DC. I'm delighted and honored to be moderating such an esteemed panel of experts on this important topic and on Human Rights Day. Before I turn to introduce our speakers, a few small housekeeping matters. Our panel will run for the next approximately 90 minutes, during which time I would invite those in the audience to please send your questions and your comments using the Zoom chat function. Time permitting, we will be addressing those questions in a Q&A session at the end of this panel. We have 6 panelists joining us today, all of whom will no doubt be already known to many of those in the audience, but let me provide you with a few words of introduction. Gopal Subramaniam is one of the most senior and accomplished advocates in India. He is the former Solicitor General of India and former chairman of the Bar Council of India. He is an associate member of 3 Verulam Building Chambers in London and has extensive experience as a litigator and in international arbitration. Sapan Gupta is General Counsel of ArcelorMittal, one of the world's largest steel producers and a global leader in industrials and mining. Sapan was previously partner and head of banking and finance at Sam & Co, one of India's leading law firms. Professor Jorge Vinuales holds the Harold Samuel Chair of Law and Environmental Policy at the University of Cambridge. He has published extensively on international environmental law, climate change, and arbitration, and has experience as an arbitration practitioner, an arbitrator, and as an expert in arbitral proceedings. Navneet Vipul is a partner at Sam & Co. He is one of the few lawyers in India specializing in environmental matters and has contributed significantly to environmental law jurisprudence in India, including through a number of important publications on this topic. Moving to my colleagues at Three Crowns, Catherine Kanzi is a partner in the Paris office of Three Crowns. She acts for corporate clients and states in all types of disputes. She's ranked for her expertise in international arbitration by a range of leading directories and has a particular interest in disputes concerning emissions trading, about which I'm sure we'll hear more today. Finally, but not least, Manish Agarwal is a partner in the London office of Three Crowns. He is a dual qualified English solicitor and Indian advocate. He is the co-chair of the LCIA's Young International Arbitration Group and is consistently ranked as a leading practitioner in arbitration and public international law. So with that introduction to our speakers, let me turn to our first topic for discussion today. Gopal, we look to you first to help us set the scene. The London School of Economics Grantham Institute has gathered statistics on climate change litigations, quoting some 1,500 cases that have been commenced since 1990. In your experience of dispute resolution in India, what types of climate change and environmental disputes have you come across, and which fora are being used to resolve those disputes?
I think there is a context which has to be placed, because jurisdictions vary in their tackling of climate change and disputes in relation to it. As far as India is concerned, I think there is considerable room for rethinking. The first is some fundamental conceptual realignments need to be made. There has to be greater congruence with the world on battling climate change. That's the first thing. The second is that India has to be conscious that 20% of power which is generated is lost in transmission inefficiencies. And the third is that innovative solutions have to be discovered. And I think the urgency and the imminence of it, which we could see not only predicted by the task force report, but in the latest IPCC report, does need to be translated into some statutory value or quotient. The reality is that even the figures which Professor Parthasarathy Dasgupta gave in his absolutely superlative report on biodiversity, the figures may be a little different as far as India is concerned in relation to human capital and the depletion of natural capital. And I think this has got to be factored in terms of auditing, in terms of costing, in terms of even profitability. Therefore, to begin with, I would say that there is a great deal of work which needs to be done in a country like India, where, like all countries, natural reserves are bound to be limited. It is the optimization, but not in short term, but I think in terms of environmental good. Having said that, there is no specific legislation which addresses climate change per se. It is time for the central government to consider an appropriate legislation. That's the first thing I would say. The second is that the national policy, which was the National Action Plan on Climate Change, is out of date. It's of 2008, and that refers to sustainable development, but we need to go forward. So we do have statutory and delegated legislation in India. It deals with different aspects, but there are three important challenges which have to be addressed. The first is that somewhere science has got to be a part of government. And somewhere, I think innovative banking and industry will also have to be a part of government. Because environment is such a major subject, it does have not only a direct impact on human rights, but I think it has a complete and a total cohate relationship with human dignity. Under those circumstances, I think there has to be some forward fronting on the question of importance of environment. The state actors, which are the state pollution control boards, have also got to be revamped. It has got to be done on objective scientific criteria. And therefore, the linkages between citizens, industry, or any enterprise, as well as environment, has got to be, I think, somewhat resolutely established. We do have environmental impact assessment authorities, but on a gradation of 0 to 10, not many would give it the most glowing colors. That is because the standards vary, the criteria are not fixed, and more often than not, there is a tendency to bypass at some level the objective definition of environmental well-being. So there is a greater need for objectivity. There is a greater need for scientific formulation of rules and criteria. And I think there has got to be a bridging by the government itself for the purpose of environmental good. In other words, it may defy, shall I say, considerations of federalism. And it might be very necessary to have an all India national perspective. As far as fora are concerned, we will talk about arbitration in a moment. We do have a National Green Tribunal. Now, the National Green Tribunal is a very highly powered tribunal. It has judicial members. It also has experts. But I think in terms of a quality audit, all tribunals, I think, must do a quality audit, because one of the important questions which arises in the world, it arises even in England, is about constitutionalizing regulatory tribunals, and also about the importance of tribunals being closer to judicial behavior. So that is an area which needs work. But the National Green Tribunal is a high-powered tribunal. It has removed the jurisdiction of judicial review in respect of matters of environment. And we have the Supreme Court of India as a final court of appeal. But then I think even there, we do need considerable technical expertise to support judicial review or appellate review. So the mechanisms of drawing on the scientific community have to become more transparent, more accessible, more available, and there has to be encouragement of the scientific community, not only in terms of environmental consciousness, but also in terms of research and development. As far as looking at the resolution through arbitration is concerned, there are various cases which have come up, but it's in the field of construction, not necessarily construction versus, shall we say, environment. But it is not inconceivable that it would arise in substantial measure in India, particularly in the light of both foreign direct investment and also when there are, shall we say, hopes held out by large technological companies about the turnover of performance. So it is a pretty fertile ground for environmental litigation. And arbitration, which the task force, and it's a great privilege to be moderated by somebody like you, because the task force report is one of the most significant contributions in this field, which outlined also very importantly in one of its chapters, what are the additional qualifications which should be insisted upon when we resort to arbitration. And there is also this careful distinction drawn in the report between an arbitration agreement or an agreement to arbitrate and submission to arbitration in relation to environment disputes. But I think we are moving definitely towards an international arbitration regime. We have subscribed to the New York Convention. The New York Convention is equally fundamental to environment related disputes by way of arbitration. So there we are on very good footing, but I think we do need to conjoin, shall we say, the possibilities of arbitration being an extraordinarily easily available remedy for the purpose of resolving such disputes. Lastly, a point which Constantine made very perceptively: what happens when you have sovereigns at issue with each other? There also, we do need to have a dispute settlement machinery very close to an arbitral tribunal. But I think what needs to be emphasized is the losing party must obey the award. If we don't have respect and sanctity for any process of resolution, then I'm afraid you could have one on paper, it could actually assemble, but when the final award is delivered, it must be complied with. Those are my observations. Thank you, Nicola.
Gopal, thank you so much for those valuable insights into dispute resolution in India and for your comments on the ICC Task Force's report, which is publicly available should those in the audience be interested in it. We'll come back to your point on the relevance of construction, arbitration and climate change issues. Thank you for that. But before we do, Novit, your practice is focused specifically on environmental law in India. What has been your experience of the types of environmental and climate change disputes arising in a domestic law context?
Right. Thank you, Nicola, and thank you for having me as a part of this panel. And I think, like it was mentioned in the beginning, what better day to discuss environment and climate change issues in the Indian context than the UN Human Rights Day. And I think Mr. Subramaniam has very nicely explained and given a sense of what the Indian scenario actually looks like. So let me take a step back in terms of, for the attendees who actually may not be very familiar with the nature of disputes that we have in this country. And so, like Mr. Subramaniam very rightly mentioned that in terms of the climate change disputes, fortunately or unfortunately, we don't have much happening in the Indian context at this stage. And clearly we see that happening in future. But in terms of the environmental disputes, clearly I would put the nature of disputes in two categories. One, of course, being the environmental activism, as we clearly put it. And the second category, of course, is where we are talking about the regulatory disputes. So let me explain a little bit in terms of what these disputes are for the benefit of your audience. So if you're talking about environmental activism, that pretty much is the major percentage of environmental disputes in this country. And of course, it deals with all kinds of environmental issues, be it air and water pollution, forests, biodiversity, costs of remediation, and you have activists, you have affected parties, you have courts and tribunals on their own, motion taking cognizance of these kind of matters. In fact, one of the things which I thought I should also point out is in the month of October, we've had a Supreme Court judgment by a 3-judge bench where they've basically said that the National Green Tribunal, as Mr. Subramaniam also, mentioned, has the power to take suo motu cognizance of environmental matters, and that's a very important development in the Indian context because this has been questioned, regularly by all kinds of stakeholders. So that gives a lot of clarity in terms of the kind of disputes that can actually be taken up. So, and having said that, I think one of the major developments has been the establishment of the National Green Tribunal, because we were actually the third country after Australia and New Zealand to have a specialized court or tribunal, for dealing with environmental matters. And so that was, of course, a great development. And to give you some examples, I thought so we've had cases where, activists, NGOs, and local residents have actually approached the National Green Tribunal opposing environmental clearances in certain matters, which are granted to industrial plants, and or even there are cases where airports have actually been opposed because the environmental clearance, the process was not actually followed properly. So and clearly, I think that if there is a process which has been established by way of a certain notification, which is the environmental impact notification, that has to be followed because clearly it might have certain adverse impact on air, water, forest, biodiversity, etc. The second, of course, example is where Supreme Court has been very proactive when it comes to environmental matters. And I'm sure most of you have about the poor around this time of the year in the national capital. So, and the Supreme Court, for example, has been doing a phenomenal job when it comes to, interfering in matters like these and ensuring that all stakeholders actually do what is required of them. NGT, like I mentioned earlier, of course, there are all kinds of NGT. By the way, there's something called the National Green Tribunal Act of 2010, and that has a section 14, which basically provides that it can take up matters. So anyone who's actually aggrieved by these matters which involve a substantial question relating to environment can approach the National Green Tribunal. And like I said, that apart from that, of course, the NGT now is there's a lot of clarity that on the basis of these letters, representations, media reports, etc., which are relating to environmental damage in any part of the country, they can actually take cognizance and pass appropriate orders. So that's a very positive development. The second example which I wanted to talk about was, of course, the regulatory disputes. And that again forms a major chunk of the environmental matters in this country. And these are pretty much disputes where you have project proponents and parties receiving closure notices from the regulators. And these could be, of course, the state pollution control boards at the state level, and of course the pollution control committees. And of course, demand notices also from regulatory authorities in cases where they feel that a certain amount of environmental harm has been caused. And these matters, of course, deal with effluents and emissions discharge beyond permissible limits. You have complaints against certain polluting projects. Maybe action is taken after a site inspection by the officials of the pollution control boards, and clearly examples of regulatory non-compliances and stuff. So that pretty much is broadly the two categories of the disputes. And let me very quickly also give you a sense of the kind of disputes which typically arise. So you have disputes with respect to grant of environmental clearances, the process of environment impact assessment, etc., compliances with consents and permits, air and water pollution, like I mentioned earlier. Waste management is a major challenge for the second largest country in terms of population, and of course we have had issues recently with respect to burning of crop waste and stuff like that. The responsibilities of regulatory authorities, I think that also has been under scrutiny. We have issues with respect to forest and biodiversity, thermal power plants, their impacts, radiations, and of course, someone mentioned about decommissioning, and of course, that's again a major issue for the future, and of course, the right to development of industries, because I think, so what in this context, I thought maybe very briefly, I'll also touch upon one matter which I have been involved with. And so of course you have these costs of remediation, which has to be paid and stuff. So there has been an example where, of course, I cannot elaborate in terms of a lot of details, but very briefly, I just tell you that you've had a case where a party has actually taken recourse to arbitration for recovering the remediation cost from the seller of a polluted site, and citing, of course, polluter pays principles. Of course, that has been challenged by the opposite party on certain grounds. But I think that is a very interesting development, and that's one example which I thought of citing. So in terms of the forums, very quickly, Mr. Subramaniam, of course, mentioned that the Supreme Court and the National Green Tribunal, of course, the National Green Tribunal clearly, and appeals from the National Green Tribunal go to the Supreme Court. There are also examples where, by way of the writ jurisdiction, we have the state high courts, so a lot of parties actually go to the high courts because, like it was mentioned that when you're talking about right to life, environmental right and stuff, you can clearly go to the high courts and the Supreme Court also. Now, one important authority which I thought I should mention about. So we also have something called the Appellate Authority. So if you, for those of you who had the chance to go through the National Green Tribunal Act, there is something called, there's a provision, section 16, which talks about the appellate authorities. And the law actually provides that, every state or union territory is supposed to have an appellate authority. Unfortunately, this is one forum which has not been utilized in the Indian context, because the idea clearly was to lessen the burden on, say, a National Green Tribunal. Because if you have any grievances against, say, a decision of the, a government department or the State Pollution Control Board or Pollution Control Committee, under certain provisions, you had the option of going to the State Appellate Authority, and most of the states and union territories right now have that. But parties, for whatever reasons, prefer to go to the National Green Tribunal, which is why I would say there is some amount of burden on the National Green Tribunal, and unfortunately, a lot of these cases are actually being referred to committees, and there are investigations, and unilaterally, say, orders are also passed. So, which may not be, I think, in the best interest of the parties always, but I think, that is something which needs to be looked into. And I think Mr. Subramaniam also mentioned about, how you need to really look into these, the criteria for appointment to these authorities and these tribunals, and, and there is a clear need to, like they say, horses for courses. So of course, that's not the right expression to use, but you need to have people who are technically qualified, people who know what they're doing, and I think that will make a lot of difference, because I think in a country like India, environmental disputes are going to rise in the coming days, because like it was mentioned that you'll have a lot of issues with respect to technology, funding, all kinds of environmental financing and stuff like that. So I just stop at that, but I think I'll stop at that, and then maybe take further questions from you. Thank you, Nicola. Thanks.
Thank you, Navneet. That's an excellent preview of environmental disputes in India, including, as you mentioned, an example of arbitration being used to resolve those disputes. Now, Jorge, we've heard some details of disputes in India, but I'd like to ask you about the international law context. You have particular expertise in that area. What, in your view, are the elements of that international law framework that are most important for countries like India?
Thank you very much, Nicola, and thank you for the organizers for the invitation. I think it's, I would just reframe things a little bit. I think that much in the same way as what you would call climate change disputes are all sorts of disputes arising from the transformation from a carbon intensive to a low carbon and resilient economy. So it has many, many different phases, and we should not expect climate change to appear with a face or dressed as climate change. Actually, basic contractual disputes may arise from actually that transformation. In the same way, the law that is relevant for climate change at the domestic and the international level is just all law read through the perspective or from the perspective of climate change. And many of the most important laws, I guess, would be surprisingly not related to climate change explicitly. And if you just think in terms of investment law and trade law, if you think in terms of contract law, just regulation, there is a lot of law that doesn't deal with climate change explicitly, but is actually driving the transformation, or is being used to fight or drive the transformation. Now, if we instead focus much more specifically of what I guess most people would recognize as the international law of climate change, which is UNFCCC and today the Paris Agreement. The basics of that law is the Paris Agreement has three main components. It has goals, it has action areas, and it has implementation mechanisms. The implementation mechanisms are less relevant for now. I guess that from the perspective of this discussion, the goals and the action areas are more relevant. The goals, we all know the goals of staying well below 2 degrees Celsius above pre-industrial time. So that means staying well below 16 degrees Celsius on average, on global average temperature by the end of the century, and make efforts to achieve the 1.5. The 1.5 is becoming increasingly realistic as a policy goal and increasingly unrealistic as something that can be empirically achieved. But this is something that we all know, but what we speak a bit less about are the two other goals. One, which is the financial goal, resilient. So there is a goal, it's Article 2.1c, that really focuses on redirecting financial flows towards a certain type of transformation again. And then there is this famous goal that is carefully crafted in Article 4.1, which is a net zero goal, which is carbon neutrality after a peaking. And peaking and carbon neutrality are not the same thing. And we will see in the next 30 years, those two goals will clash. Because, and I guess that to see how those goals could clash, the best way to look at it is what has happened in COP26 and the announcement by Prime Minister Modi during COP26 about what India is planning to do. And India is planning to go net zero apparently in 2070. Which would be broadly consistent with Article 4.1 of the Paris Agreement. And it is also, at least Prime Minister Modi announced that half of the energy that India will consume will come from renewable sources by 2030. That's a very ambitious goal, very, very ambitious goal. And it looks much more at peaking, it's closer to peaking or pre-2050 ambition than about net zero. Net zero is a very complex animal to read, and we can talk about that later during the Q&A. So you see that this is essentially what India is planning to do, and however it does so, it will require transformation. And when I talk about transformation, I'm not using that word lightly. I am using that word because from an economic and policy perspective, that means industrial policy. Industrial policy to redirect flows and to create new industries and to redirect flows, financial flows, into essentially 2 or 3 main areas. One, which is energy. You could include in energy transportation, but you can also treat transportation separately. So it's transportation, energy, understood as electrification and a move away from coal. India has in its hands the future of coal and the pace of the coal decarbonization process. And then, of course, the issue of industry, decarbonizing industry, and particularly some sectors, iron and steel, that are very important. So if you look at the transition of India, as many other transitions, is going to be a regulatory change pathway. And that the direction of travel is, I guess, more and more settled. There may have been a doubt about the direction of travel in India last year, but it looks increasingly set. Now, as for everywhere else, what is really going to count is the form of change. But I think we can talk about that in a moment. Thank you.
Okay, thank you very much. Well, your comments lead me nicely to ask Manish to come in and discuss Fora. In particular, Manish, is there scope for arbitration to be playing a role in the resolution of some of the climate change and environmental disputes that will no doubt arise in the economic transformation that Jorge reiterated we need to see in the forthcoming years?
Thank you, Nicola. And I think, as our other speakers have mentioned, arbitration is already playing and will likely continue to play, in my view, a substantial role in the resolution of such disputes. Of course, much will depend upon the type of climate change and environmental dispute as well. Navneet referred earlier to a number of domestic cases that have been brought by NGOs and shareholders and regulators to change climate-related policy or conduct by states and corporations, and often by reference to constitutional or administrative laws. And I think for those kind of disputes, you can see how many claimants may still prefer a more public forum, such as national court litigation, or a specialized tribunal, such as the National Green Tribunal, to exert PR and reputational pressure on the respondents. Of course, in the arbitration context, you need a consent-based instrument to generate that standing, which may not always be the case for such disputes. But if you contrast that with purely contractual disputes that are arising from climate-related events, we've seen a number of cases involving force majeure, for example, or you look at the contractual disputes arising from the transition, adaptation, and mitigation measures that the other speakers have mentioned earlier, or investor-state disputes, to which we will return. You can see a number of factors that will lend prominence to arbitration. And let me highlight very quickly 3 factors. First, if you look at the sectors that are undergoing this metamorphosis, arbitration is already the preferred dispute resolution method in many of those sectors. And as the number of transactions in these sectors increases, and as the nature of these transactions involves novel technologies, new markets, new relationships, you can expect a concomitant increase in the number of disputes that are referred to arbitration. The second factor is that due to the neutrality and the wider enforceability arbitration offers, as has been said, it is effectively the only game in town for the resolution of cross-border disputes, particularly where you have state parties or parties from emerging markets who are again going to play a big role in the transformation that we've talked about. And I think the final factor, just picking up on what Gopal and Navneet mentioned, is a flexibility that arbitration offers, right? In terms of parties being able to choose decision makers who have the relevant scientific and technical expertise, the ability of the parties and the arbitrators to tailor their procedures to the specifics of the climate change disputes. I think that's also going to translate into a preference for arbitration over litigation for many such disputes. I'll pause here.
Thanks, Manish. Catherine, perhaps I can invite you to come in on that question as well. What are your thoughts on the role of arbitration in this context of addressing climate change?
Yeah, so I have to say that I don't have much to add to the very complete response that Manish has given, which I 100% agree with. But perhaps one can answer by reflecting at some short length on what disputes are currently going to arbitration, and then on whether there are additional areas in which arbitration could be used or should be used. And of course, the starting point, as Manish quite rightly pointed out, is that arbitration is a consensual mechanism. So disputes will go to arbitration if there is some expression of reciprocal consent. And of course, that can be expressed in a treaty, and we'll come back to the treaty disputes, or in a contract. And so just to pause on the contractual front, as we know, contracts relating to large projects, and I'm talking about everything from energy to oil and gas, telecoms and the like, and notably projects involving an international relationship or investment, those projects are typically governed by contracts that will provide for arbitration as the means of dispute resolution. So the reality is that we are seeing, and have been seeing since time immemorial perhaps, a broad range of environmental disputes being heard in arbitration, because of course the reality is that any project is going to have some manner of impact on the environment, whether positive or negative. And I might offer just a few examples, and what's striking is how similar they are in substance to the examples that Nani gave, which illustrates that a lot of these disputes can be heard in arbitration or in litigation. And of course, Manish has set out the factors that might lead parties to choose one over the other. So on the examples, what we've seen in our practice, a dispute involving a contract for the laying of a pipeline. The contract, as you might expect, and as is increasingly the case, included obligations in relation to environmental remediation after the laying of the pipeline, and a dispute arose as to whether those obligations had been fulfilled. We've seen a large number of cases, similar cases, under oil and gas contracts, which also typically contain, as you know, remediation obligations that kick in at the end of the contract. And we've also seen disputes in relation to environmental issues at the beginning of a project, when an environmental impact assessment, for instance, has to be performed. And that, of course, we see increasingly in the laws of most jurisdictions. And that can give rise to disputes. So Constantine referred earlier to a case that we had involving the cancellation of a waste to energy project. Well, the issue there, and we acted for the state, was whether the state properly canceled the project because the environmental impact assessment was insufficient. And we ended up prevailing. In a similar vein, we had a huge arbitration that ran for over 10 years about a nuclear power plant. And the key question was whether the design was safe and what regulatory oversight could have been anticipated in that regard. So yes, arbitration is playing a role in the resolution of disputes that have environmental dimensions. And so I suppose the more interesting question for reflection is the forward-looking one, which is not when is arbitration used, but when should it be available? And I won't repeat Manish's observations. As I said, I completely agree with them. And I think that the consideration was comprehensive. The short answer, of course, is it depends. Much of what's in the courts probably belongs in the courts, but I do think there are specific areas, including notably where international issues are involved or some kind of international harmonization is required, where we might see and might advocate for new rules for arbitration. And I think, Nicola, what I'll do is pause there. The example that I'll give is emissions trading, but we're going to come back to that. So perhaps I will reserve my reflections.
Thanks, Catherine. We will indeed, and we'll also come back, I'm sure, to the theme of international disputes and cross-border disputes. Before we do, I don't see you on my screen, but Sapan, are you there? I had a question for you. Sapan, thank you. You've been patiently listening to our discussion so far. You provide an extremely valuable and important in-house perspective. What, if any, is the impact of the broad climate change related transition on corporates like ArcelorMittal? And what has been your approach to managing risks or potential disputes arising out of this transition? Excuse me.
Thank you, Nicola. Thank you for all the panelists for sharing their remarks. From an in-house perspective, there's a lot of background work where we are getting ready for. And in a way, it is moving much faster than we expected. So there are three parts where in-house or the companies are getting affected. One is the legislation building. Us being a very large company in Europe, and in Europe acting as a home base for these legislation, we are quite involved with the EU and the Commission. The second piece for us is contracting, which is procurement, sales, and every aspect we spoke about. But because for arbitration, we will need contracts to begin with. And the third is the M&A aspect. Is that where do you see opportunities for future? As an industry leader, we believe that we have to play a role of consolidating the smaller initiatives, be in terms of technology, be in terms of finance, and then make an aggregate of all of that and try to create a solution for an industry. So on the legislation, all of this is flowing from health and safety, where it is very important that we build both internal and external culture. So we keep health and safety at the top of our agenda. Most of our meetings actually start with health and safety updates. So it's extremely important for us that we build an internal culture of importance to this topic. On the external aspect, we liaise with a number of regulators, be it Euro, be it devising of, say, emission performance in Canada, be it greenhouse gases emission in Brazil. Then we have similar legislations in Mexico and Ukraine. But none of this exists in India from today's discussion perspective, and there is a fair amount of work which needs to be done. On the contracting, it's on the both sides because we buy a lot of material, which is mined, which has another environmental obligation. And then we sell to automotive industry, which is again held responsible or made responsible for pollution. And there are a number of procurement contracts because we are a real industrial. One is signing new contracts, that how do you build scope and in processes that we reduce the carbon emission. The other aspect are the ongoing contracts, which you can't really change on your own. So you have to engage with the parties to see that how we can go through it. On M&A and transformation, M&A has two pieces for us. One is to buy the new companies. The second is not exactly M&A, but our internal movement. So say like in Spain and in two places in Germany and in Ghent in Belgium. So we are transforming our current projects into to hydrogen-based or various other means which we can do. So all of those activities needs to be partnered with. So as a legal team, we have an important role to play on those transformation and aggregation. So that's really on the in-house part and where we are involved on day to day and how we want to deal with it. In terms of people, that's a big challenge. It's not really spoken about. Is that, do you have enough talent? Or do you have enough? One is enough standards, which Jorge also spoke about. It is the lack of resources. It's something which is everyone cares about, everyone wants to do, but there are not enough people on the ground, even for law firms, and that's why I was very supportive of this initiative. That real thought making is required. Thought leaders are lacking. It has to change from a commercial opportunities of law firm and practitioner to say that, oh, we have an ESG practice, but how much can you contribute on real basis? So we face a considerable amount of challenge as in-house to build internal strength as in-house concept, who can deal with these different moving parts without any standards, without any code books, without any rule books, and then a serious commitment of our organization to achieve net neutrality by 2050. So it's a little bit chaotic. What worries us as in-house is that, and then we spoke about it earlier, is that who will reach first? Arbitration will happen, but there are no neutrality standards which are globally accepted. Every jurisdiction has its own interpretation, has its own status of evolving. And will we face litigation before we really know what we are tackling? Will the industry get enough time in real earnest to make a proper crack at it? Or it will become a case like Shell, which we will speak later, that you are asked by courts to do 45% emission, but what is the definition will not be defined by a district court sitting in one European country, rather than the complete debate that how it will happen. So we really believe that that the dispute really comes into place when we have some guidelines of what are the rules of the game, so that industry can adjust to it before they are asked to react to it, or before they are imposed with high fines or performance obligations. That's what I would say, Nicole.
Staffan, thank you. That's some fascinating insights, and it's clear that climate change and environmental issues are impacting significantly on your team's work. And it's also very interesting to hear about the uncertainties facing companies as legislation is in flux, and the pace of that change is also uncertain. Manish and Jorge, if I may, I'd like to pick up on a slightly different topic, and it's a point that was raised earlier about the role of investor-state arbitration. We heard earlier that we're already seeing and can anticipate an escalation of legislative and regulatory changes by states. These changes are part of states' transition to a low-carbon, sustainable, climate-resilient economy. And at the same time, states are grappling with who should shoulder the fiscal burden of that transition. This could have serious implications for the profitability and viability of certain investments. Manish, perhaps starting with you, what are the kinds of investor-state disputes that have already arisen in this context, and what are the issues that tribunals need to deal with in these disputes?
Thanks, Nicola. I think leaving aside one instance in which a Canadian investor sued Barbados for breaching investment treaty obligations because it had failed to enforce domestic and international environmental laws, I think there are two broad contexts in which environment and climate change related disputes have been addressed in the investor state context, and Constantine mentioned them in his opening remarks. The first category consists of claims by investors who have faced state measures favoring newer types of energy or which are otherwise aimed at protecting the environment. So, we've heard about claims in response to withdrawal of fossil fuel subsidies, phase out of energy sources such as coal, or introduction of stricter emission standards. The second category consists of claims by foreign investors in new energy who are faced with states' withdrawal or alteration of incentives that were designed to attract investments into those new energies. And in terms of my own experience over the last decade, as Constantine mentioned, we've been involved in several such cases as Council, particularly under the Energy Charter Treaty in respect of 4 states' revocation of feed-in incentives for the renewable sector. And I should note that these claims have arisen primarily in the context of the old generation treaties rather than the newer generation treaties that contain more elaborate provisions regarding environment and sustainable development. And these cases have given rise to very complex issues at each phase in the life cycle of an investor-state arbitration, be it jurisdiction, liability, or quantum. And in the interest of time, I'll just limit myself to some remarks about the kind of issues that have arisen at the merit stage. And as Constantine again mentioned earlier, at the merit stage, the key issue for tribunals has been where to draw the line between a legitimate exercise of a state's regulatory powers entailing no compensation on the one hand, and on the other hand, a compensable breach of substantive protections such as the fair and equitable treatment standard. And essentially, it really boils down to who bears the economic burden of the change. And I think, unfortunately, the arbitral jurisprudence is quite fragmented, and it generates a lot of uncertainty for both investors and states. If we take the FET standard, for example, most tribunals now acknowledge that this standard does not prevent a state from making regulatory changes in the public interest. However, it is also recognized that that power of the state to make changes is not unfettered. It is constrained by its obligations under the treaties. And what does that mean as a practical matter? Tribunals have said that states cannot breach a stabilization commitment in a contract, or if there is a specific representation to the investor that it would not make certain regulatory changes, you can't really go against that representation. What is unclear in arbitral jurisprudence is where you don't have those contractual stabilization commitments and you don't have those individualized state representations. You have one line of authority that tells you, well, you should look at the degree of change. Is the change radical, total, or drastic in degree? Other tribunals will tell you, well, you must look at the unreasonable or disproportionate nature of such change. So as for the first test, how should one assess whether a change is radical, drastic, or severe? Is one focusing simply on the economic effects on the investor? Or are you actually looking at the proportionality, which is, some tribunals pitch it as an alternative test in any event? And I think these are very important issues in the context of climate change regulation, which by design may introduce what may be perceived as drastic or radical changes. I think the key takeaway is that for both foreign investors and states, it's absolutely critical to be aware of these issues, how investment tribunals are deciding them, and really take specialist advice when it comes to structuring their investments or designing their laws and regulations in this context. Because what you don't want to do is to either find yourself as an investor exposed to significant political risk without any international law protection, or as a state exposed to liability for an internationally wrongful act because you didn't comply with certain minimum standards of treatment under international law. But I'll pause there and give Jorge an opportunity to weigh in as well.
Please, Jorge, your thoughts are very valuable. No, go ahead, please.
No. It's. I think that in simple, the direction of travel, as I was saying earlier, is no longer at stake. So in the early days, I have been following this for some 15 years, with roughly, and you have right now something like 1/5 of all the publicly known disputes that have an environmental component, and roughly half of that is energy transition cases. Now, in those energy transition cases, you have a very, very sort of small category, but growing, which is brown versus green, or brown versus green policies, which is what Constantine was mentioning earlier, and Manish as well. So we have some companies that are challenging. Now, interestingly, even those companies are not challenging the purpose, they're challenging the form. So, and this is, I think, an key. It is too late to challenge the purpose. 15 years ago, it was not too late. I remember the early cases were all about challenging the purpose. Today, it's challenging the form. Now, there is another category of cases, which is sort of within the green sectors. And in this category of cases, it's quite obvious that it is about the experimentation, the bumpy ride of actually going green for a state and also for a company, or for companies to invest in green. Many of the companies that are investing, or that were investing in the early renewable energy BEIG cases, were investors, financial investors, with no prior experience in the renewable energy industry. So you have a number of issues that this process of adjustment, of transition, will be bumpy, necessarily. So on that aspect, let me say just two things. The first thing is about what is the core issue, and the second thing is about some new forms of disputes that we're not talking about that much, and I think they're going to be very important. So on the form of the dispute, on the legal form of the dispute, there are two ways to go about it. And Manish was talking about going about it through the general concept of investment law or trade law. And there, the bumps are very, very sort of pronounced, because this law is not specific enough. So there you have to come up with parameters that are broad, and the typical parameters being, aside from the public purpose, non-discrimination. I mean, if you win on non-discrimination, you win the case. Or you have to look at due process. Again, if you win on due process, you may win the case. If you look at proportionality, you have a harder case. But you have parameters that are common to a range of general concept of investment law. There are also some tricks there, such as whether you frame something as an exemption or an exception. And there is very often this is something that counsel does not see sometimes, and that leads to very important implications in the decision. So this is one way to frame it. Another way to frame it, which is still wide open, is because states don't feel safe enough to go through that transition and undergo litigation risk without a specific clause. So you see more and more clauses that try to make space for that transition. And so far, the practice on the operation of those clauses is erratic, is not clear enough. There are four main cases. We can talk about them later in the Q&A, but essentially you have differences between, dealing with that at the level of jurisdiction, or dealing with that at the level of merits, dealing with that as a presumption, dealing with that as mere interpretation, dealing with that as a defense, as an excuse, dealing with that at quantum. It's wide open, and that's a problem. So that's a framing. So there is no clear sort of safe harbor to go to. There is no pathway that is shielded from litigation or from problems at the level of compensation. Now, what are the disputes that I would like just to mention? And then we can discuss them later. A lot of the disputes that are not being mentioned but are very important are supply chain disputes. And Constantine mentioned a supply chain dispute about wind energy equipment. Now, this is contractual disputes, right? This is happening a lot. And supply chain disputes also have an interstate or investor-state dimension. And just think in terms of the carbon border adjustment measures that have been proposed by the European Commission. Now, introducing that disrupts the supply chain. And in the past, there have been quite a few disputes in investment that were about trade-related measures. And we're not talking about them. We're not talking about them because we're not seeing that the transaction is based on a supply chain. Second, we're not talking about basic extractive industry disputes that are about critical raw materials. Now, the transition to a low carbon economy and actually the transition to digitalization and actually artificial intelligence, automation, and defense, all that requires certain raw materials that are not evenly distributed and on which China has a dominant position. So we're seeing a number of disputes that are never mentioned in climate change accounts or in environmental accounts that deal with essentially where to find those things aside from China, elsewhere from China. And they may include, for example, disputes relating to seabed mining, deep seabed mining, the area. And then the last category of disputes that I should probably mention, but it could fit somewhere within the green sector, is disputes relating to market mechanisms that have been given a new life after COP26, because two key decisions unlocking the possibility of internationally transfer mitigation outcomes on the sustainable development mechanism, they have been drafted, so we have a clear pathway on that this is going to happen. It's going to be more and more. That involves commercial disputes on emission reduction purchase agreements, ERPAs, as in the old days, and it includes also project-based disputes, so disputes about not getting the credits as you expected. But we can talk about that over the Q&A.
Thank you, Jorge. These are fascinating thoughts on sectors that will be implicated in the future. Supply chains, as you say, deep seabed mining and emissions trading, which is an issue that we'll come on to shortly. And that leads us nicely to the next part of our discussion, which is to focus on specific types of commercial disputes. Gopal, I could ask you to come in here. Earlier, we identified the importance of construction and infrastructure sectors to addressing climate change mitigation and adaptation. What has been your experience of environmental disputes involving those sectors?
Well, to the extent I think an environmental dispute is sufficiently incorporated into a contract and becomes a contractual obligation, it can often be a part of a construction dispute. But there are some issues which arise in relation to causation of damages in such matters. The theory being that in public law, the polluter pays principle is a very catchy phrase. It does lead to what could be in the law of tort fringe around exemplary, or shall we say even non-direct damages. But the law of contract does in fact only permit what are called causatory damages. So there is this little tension which happens between the overlay of public law remedies of the powers of the court to award compensation versus the restrictions imposed by the law of contract in relation to the award of damages. The second area, which is also an area of some tension, is the tendency of tribunals to find on principles of strict liability, although they don't say strict liability, but they march towards implicit assumptions of strict liability can be a little more if it comes to matters relating to environment. So environment is also a kind of it's an area which does need a more grappling, I think, in realistic terms, in pragmatic terms, even in terms of adjudication. So what might be called a good deterrent effect in terms of compensation in public law may not actually set the standards for the purpose of assessing truly causatory damages. And causatory damages are also not easy to identify when it particularly has got spillover effects. Then how do you measure spillover effects, and who does it? What kind of expert is he who can actually measure damage that way? These are challenges. They do arise in construction disputes. These are challenges which also, I think, come before courts. There is no ready and rational method except I think looking at the best possible awards which we can see. And somewhere, I think a point which was made by many of our colleagues here is that if you see across the board, the best quality of awards rendered by international tribunals do have, I think, fairly salubrious guidance, whether it be investment treaty or whether it be, shall we say, two sovereigns which have a dispute in relation to territory or the law of the sea. There are some principles of what we call as containment, management, lack of transnational harm. All of them do persuade tribunals to come to fairly reasoned and accurate conclusions. Somewhere you have to import these into domestic context and internalize them and give numbers to them. But giving numbers to such principles in a domestic context is more of a challenge because, again, currencies vary, even climates vary. So there needs to be more factoring. And that does involve, again, I think, expertise, which is why, as I said, there has to be a great deal of bridging between between statistical calibration of losses, statistical calibration of effects of, let us say, breaches, particularly if it's a breach arising out of an environmental obligation. And then is it a loss which is in rem or is it a loss which is in personam? Because if it is arising out of a contract, you can only get hold of the principal contractor or the subcontractor, the follow-through contractor. And lastly, we're also going to tackle the question relating to manner of quantification and what happens if there is a time and cost overrun, not matched by efficiencies of scale which are promised. So how do you offset one against the other? This also requires, I think, a certain degree of very insightful training. But I would be very optimistic to suggest that considering the quality of most of the awards in international in investment treaty arbitrations, there is a great deal of wisdom. I think, as George said, it is possibly when you have the bumpy ride, one has got to be cautious. You've got to be very cautious when it comes to territory of proportionality as it is understood. But otherwise, I think you could draw sufficient inspiration from many of these awards. And I think that's been the great contribution of international arbitration, international commercial arbitration itself, or investment treaty arbitration, has contributed so profusely, I think, building upon fundamental principles of international law translated into disputes.
Gopal, thank you. That's fascinating. And you've picked up on 2 points that I think Catherine will also find particularly interesting. That is complex questions on causation and quantification of damages and in the context of construction disputes. So Catherine, what in your experience are the climate change issues that arise in those contexts?
So you're absolutely right, Nicola. I was having given some examples of disputes in the construction sector earlier. I was going to come at the question from a different angle, and it's precisely the angle that was highlighted by Gopal, who quite rightly observed that these disputes raise complex technical questions of causation. And I would underscore that the question of causation in these disputes in particular is relevant not just at the damages phase, but also to the merits. So questions like, what is the immediate impact of a project? What are the ripple effects of that immediate impact? How can they be prevented or remediated? And how can all of that be monitored? And of course, those technical questions don't have easy answers, at least not if you're going to answer them properly. And we also heard Gopal earlier make a call for greater reliance on the scientific community, which is precisely what we'll have to do and have been doing in arbitration. And indeed, I think you're going to be seeing increasingly a presentation of some highly specialized experts in these arbitration proceedings. We're seeing it already. And the good news is that there are some highly sophisticated tools out there to establish causation, but it's really quite a challenge to explain these to tribunals, and they give rise to novel evidentiary debates, including about data processing, data boundaries, and the use of, as Gopal quite rightly said, statistical analyses. So I thought what I'd do was illustrate briefly. It's an example, you see it on the slide, that actually is close to home for this audience, although it's from the New York Times, because it relates to Afghanistan, including India's influence in Afghanistan. So this all came about because in 2009, the US Army famously commissioned a study of military strategy in Afghanistan. And what they wanted to do was take into account all of the myriad interlocking factors influencing what was happening in the country. And in order to do that, they used a computer modeling technique called system dynamics. And the complexity of the analysis was pilloried in the press. You see an example here with General McChrystal, who was then the head of NATO, quoted as saying, when we understand that slide, we'll have won the war. So of course that didn't happen, neither happened. Why do I bring this up though? Well, it's an example that's close to my heart because I lived in Afghanistan for a few years, but more significantly for this audience, I raise this because it's the same technique that's being used for some of the more significant climate change modeling. And it's also the technique that I used in order to establish causation in the nuclear power plant case that I referred to earlier. And funnily enough, it's actually the same experts. They all come out of MIT, which I think is a school that's known well to this audience. And so there are a few lessons that I wanted to share with you and this audience coming out of that experience that I think are particularly relevant for environmental disputes. The first is that the experience has very much changed my perspective on tribunal appointed experts. I think I had a very common law approach before with some notion that I would perhaps lose control of the dialogue if the tribunal had its own expert. I now realize that tribunals need help, and they're not getting it when you have battling experts on either side if the technology is too complex. So there really is a role in some cases for tribunal experts. Second, the experience underscores for me that lawyers are going to need to be more creative about cross-examination, because the reality is that when you're dealing with this kind of evidence, you're just not going to be taking witnesses through documents. You're going to need to do something that's more complex, and that's going to be a challenge for you. So I should say that I've twice now done some live modeling in Cross to, I hope, some success. Once using Excel and once in this nuclear power plant case. And that brings me to my third point, which is related, and that is that if you're going to do that, if you're going to be using these technologies and dealing with them in cross-examination, then you need to be thinking quite strategically about how you organize your hearings and what technology is going to be available to you. And there are extensive new tools out there that are increasingly common, but perhaps not as well known as they could be. There are many more experiences that I could share and insights that I could share, but perhaps I'll pause there, Nicola, as I know there are other interesting subjects to cover.
Thank you, Catherine. And yes, there are a number of other topics that I wanted to bring Manish on now to speak on, and that is the decommissioning of assets. You mentioned this earlier. It would be very interesting to have your further thoughts on the relevance of disputes in that context.
Thanks, Nicola. Just a quick word of explanation. When we talk about decommissioning or abandonment, what we are essentially referring to are activities that are required to dispose of assets, which could be oil and gas installations or power generation facilities, and to eliminate their environmental footprint when they reach the end of their economic lives. And to answer your question, Nicola, the topic is particularly relevant in the Indian context, picking up on what Gopal and Navneet said earlier as well, because the legal and contractual regimes regarding decommissioning are rapidly evolving as a significant number of assets in India are coming to the end of their useful lives, or because of the phase out of certain facilities due to the climate change commitments. And just to take one example, just last month, following directions of the National Green Tribunal, India's Central Pollution Control Board issued draft guidelines for decommissioning of coal-based power plants, proposing a whole range of new measures, including environmental management plans and environmental impact assessments for the decommissioning process, all of which will, of course, entail significant costs. And what's happening in India is consistent with what we are seeing across the globe, with a wave of decommissioning expected over the next few years. And just to share some statistics, it is estimated that around 2,000 offshore projects will require decommissioning between now and 2040, with estimated costs in the region of around $200 billion. If you look at India itself, I think around 2,000 megawatt capacity worth of thermal power plants have been identified for decommissioning in the near future. And that increase in focus on decommissioning is accompanied by a corresponding increase in the number of disputes. We have grappled with those kind of issues in a number of cases, and particularly in the oil and gas sector. And I just wanted to pick up on one particular aspect that may be of broader relevance as investors and states think about evolution of regimes and contracts in the context of decommissioning. If you look at the modern long-term petroleum contracts, many have detailed provisions on decommissioning, allocation of liability, how that liability should be funded, for example, by establishment of an abandonment fund. But if you compare that with the earlier generation of petroleum contracts, particularly those that were entered into in 1980s and 1990s, and a number were entered into in India as well, and those are now coming to an end, most of them do not address the issue of decommissioning at all, or in any level of detail. And that is because people were not really focused on the end of assets' lives at the time. The real focus was on getting those assets operational. But what has happened since is that in response to the increasing amount and costs of decommissioning activity, the increasing emphasis on environmental implications, many states have started enacting laws and regulations that impose decommissioning liabilities on contractors, and in many cases on a retroactive basis. And now India is no stranger to retroactive legislation and the implications it may have for a state in terms of investment claims. But even in the contractual sphere, it has given rise to a host of issues. So if you take, for example, contracts that do not expressly provide for who bears the decommissioning liability, right? So you take the context of a lot of these thermal power plants in India, which do not have any provisions for decommissioning. But a lot of these contracts, because of their long-term nature, may indeed have stabilization clauses that grant protections from later enacted laws and regulations. What you then find is that where states enact a retroactive regulation or law, that you then have a conflict. Investors would say, well, that is in breach of the stabilization protections. It's not an economic risk I had assumed at the time of contract. And what the states will then say is, well, to the extent the contract refers to good industry practices, which are quite common in these kind of contracts, they import into the contract modern decommissioning practices, the evolution of the law, is accommodated by those provisions. And again, those kind of disputes are now arising in arbitration. Tribunals are grappling with it, and I think they're going to have a huge bearing on the allocation of that economic risk, both in the contractual and in the investment space.
Thank you, Manish. Very interesting issues there. And from decommissioning, let's turn to emissions trading. Catherine, you have a particular interest in this issue. At the Glasgow Climate Summit, and this is a point that Jorge mentioned earlier, states made important progress on agreeing some of the rules relating to new emissions trading under the Paris Agreement. And emissions trading appears set to become a very important element of the global response to climate change. Do you foresee emissions trading as being a potential source of disputes? And if so, what are the kinds of issues that would be raised? And does arbitration have a role to play in resolving some of those disputes?
Thanks, Nicola. So what I thought I'd do to start with is to explain the relationships, because of course you need to understand the relationships that are created by these emissions trading schemes in order to understand the types of disputes that might arise. So I have a series of notional representations. This audience will know, and in particular this panel will know, that I am simplifying drastically for the sake of illustration. But with that caveat, what you see here on the screen is a notional representation of a basic cap and trade scheme. So you see at the top that there's the state or an interstate body, and I'll come back to the Paris Agreement. Some manner, though, of state authority imposing a limit on emissions in certain sectors, and that will be defined. The limit will typically decrease over time, that's the point. And the actors in the sector or sectors that are covered will need to procure allowances in order to emit, whether that be carbon or other greenhouse gases. Sometimes they're referred to as emissions allowances, sometimes emissions credits. There's a great variety in the terminology, but fundamentally the approach remains the same. And you see that relationship, so between the state and the emitting entity, in green on the left in this diagram. The key to these schemes and to their accomplishment of climate change prevention goals is what you see on the right, which is that credits or allowances can also be generated, and they're generated by carbon negative projects like reforestation or carbon capture. And you see that in purple on the right. And then what's also key is that the allowances or the credits can be sold in commercial transactions on the market. And you see that in black at the bottom. So notionally, three types of relationships. And whenever there's a human relationship, there's the possibility that it's going to go awry. So notionally, three types of disputes. And so to the question, what are they, and are they going to go to arbitration? Well, let me first consider the disputes with the regulator. So the relationships in green and purple. What I'm seeing is that typically those disputes are going to go to whatever the court is of the state or the intrastate body. So for the EU, disputes go to the European Court of Justice, and there have been maybe a dozen cases, including, interestingly, from this audience, one involving one of India's star companies. There's, of course, a slight twist where foreign investors are involved, either as the entity subject to the limits or the entity that is generating credits, because, of course, foreign investors may be protected by an investment treaty, in which case they'll have the option of going to arbitration rather than whatever the domestic institution is, rather than the domestic court. And of course, we saw earlier a comment to the effect that that creates an uneven playing field, and that's absolutely right. So just taking the example of our Indian company before the European Court of Justice. And I think that company in that case was somewhat disappointed by the outcome. An alternative avenue for that company would have been to bring a claim under any applicable investment treaty. And that, of course, would be a claim in arbitration, typically. And there has indeed, as Constantine alluded to earlier, been a claim brought by an investor against Canada, and it's a purple relationship type claim. But other than that, I'm not really seeing arbitration in relation to this regulatory relationship. What I am seeing, though, is the possibility of arbitration and the existence of arbitration in relation to the commercial relationship. So the trading, which you see here on the bottom. And in particular, we've seen a number of disputes brought to arbitration in relation to emissions trades. But perhaps upstream of that, it's worth observing that some of the more widespread standard form contracts that are being developed, and I'm thinking in particular by the standard forms that are being developed by the International Emissions Trading Association, they provide a possibility of going to arbitration. They, in their dispute resolution sections, typically allow for a choice between litigation and arbitration. And interestingly, for arbitration, they contemplate either ICC arbitration or arbitration under the PCA's specialized rules. Of course, the parties could pick whatever they want, but it's interesting that the fingers are pointing in that direction. And what's also interesting is that there is an opening to arbitration at all, because in the ISDA Master Agreement, which is the standard form agreement for swaps and derivatives trades, as this audience will know, and it's actually also used for some carbon trades, in particular the derivatives trades. The ISDA Master Agreement contemplates only litigation, and that is, historically the banking sector has gone to courts, not to arbitration. So as I say, that opening is interesting to arbitration. That, Nicola, was for disputes under the basic scheme. Of course, things get more complex, the relationships get more complex, and therefore the disputes more complex once you start to layer on top of that the fact that schemes are being linked internationally. And then, of course, a global scheme is being developed under the Paris Agreement. I'll pause there. I'm happy to take questions if there's interest in time.
Thank you, Catherine, for those insights into such an interesting topic and source of disputes. Another important outcome of the Glasgow Climate Summit was a recognition of the importance of climate finance for funding mitigation and adaptation, particularly in economies like India. Sapan, we know you have significant expertise in banking and finance. There's been a lot of discussion around innovative financing instruments and their role in helping, for example, to de-risk much needed investment in climate change efforts. What is your experience of climate change or environmental finance disputes?
Thanks, Nicola. Before I go there, I'll make a comment on what Catherine put as a presentation. The challenge we are facing in this is when you approach a government and you start discussing with them, it is not clear where this environmental financing is sitting. The government was either used to giving you certain resources as a low cost, like giving you a leased land or a leased mining, or was doing a public-private partnership, as we call in India, that they will come as a JV partner and do it. In environmental matter, they are willing to put the funds down, but they are not really clear that is it a management control? Is it a financing? Is it a social obligation? So when we are drafting these contracts with them, and this is across the globe, we are doing projects in Africa, we are doing projects in Canada with government, then what is the nature of this financing or this support? Is it a debt, it's an equity, or it's a social cost? So that clarity is not coming. And that clarity is leading to a lot of delays in this contracts getting finalized. Yeah. And when you discuss with the government, and federal and state is very important, and Mr. Subramanian mentioned about it, it's not only an issue in India, we face this in Canada and many other countries, is that what sort of contracting you are going to do. And the first preference which comes is of course the national law, because they have an added advantage. As an MNC, you say, look, we don't prefer a local law. So you end up falling in the basket of arbitration. So arbitration is also coming in as a sort of solution that we are not agreeable to a local law because we are partnering with the government, and they are not agreeable to a common law jurisdiction like London or a commercial jurisdiction like a New York. So you end up towards an ICC. And depending on what part of the world you are in, you may end up being at London or at Singapore. So as I said, that for arbitration to happen, the contract has to happen. And then for contract, we are really struggling with what's the dispute resolution and how it will get structured. Now coming to the financing part, there are two parts to it. One is financing as a nation, and then financing as a private investor. You look at the Glasgow, of course, India wanted to say that you put a deep regret clause or deep regret comment that the Paris Agreement commitments have not been followed of 100 billion. So the developed nation should acknowledge that the financing has not happened. And now, by the way, the demand is not 100 billion, it is 1 trillion, which is as a developing nation as a whole. And 1 trillion is a large number. It's something like 1/3 of India's economy on the GDP basis. So there's a big disconnect that how much is the amount, and then who will pay it? Are we expecting that the taxpayer in developed nation will fund environmental control in developing nations? So there's a huge issue around what's the amount and who's going to fund it. And the answer to that cannot be very simple as India would put it, or China would put it, that you polluted the world, now it's our turn to pollute. So hence you have to fund me. It's not going to happen like this. It's the pollution in India, which is a cause of concern for the Indian population or the Chinese population. So, and on top of that, you have an added the self-respect problem, that how the economies have moved in the last 20-30 years, where getting foreign aid was not a problem. Now getting foreign aid in a country like Brazil or in India is also a political issue, or also a cause of a thing that we want to sit on the UN permanent seat. And at the same time, we don't mind being funded for environmental pieces. We don't mind World Bank or IMF coming and saying, okay, take 50 billion or 100 billion to fix your environment. So there is this give and take which is happening, which we don't know how it will parallel out. The second part is the financing, especially in the Indian context. If you look at green bonds globally, 2020 there were about 200 billion issuance of green bonds. 2021 there's an expectation that it will be about 450 billion. India has done about 7 issuances. 2017 SEBI came out with this green bond listings. We have defined process. We have about 3 or 4 things where you can call it a green bond for the end of use, like clean water, clean transportation, and anything done for the climate. It's increasing, but it's really not increasing in the sense that first, the same global issue comes in, that what exactly is green? What do you mean by green? And second is at the end of the day, are you able to convince the investor that you please invest in a green bond versus a normal bond because it's green, though the return would be lesser or at par. So that mindset may have shifted in Europe, that you are fine with getting 20 basis points less, or you are fine with signing up with an electricity company, which is slightly expensive because in a way you are contributing to the environment. The India or the developing countries have yet not reached that you are going to pay a premium because something is indirectly contributing to the environment. The good developments are that Ghaziabad Municipal Corporation, which is a town near Delhi in northern India, which is one of the most polluted districts, have issued bonds of about 20 million. Small amount, but it's a big amount, about 20 million earlier this year. And then there is a bit of an irony that it's probably one of the most polluted town in the country, and then they have gone and issued green bond as municipal corporation, and it was oversubscribed by 3 times. So there's a shift. Power Finance Corporation did that. Some of the very large corporates in India have issued green bonds. And then there is sustainable finance where a lot of foreign banks are coming, a lot of foreign banks in Indian context are coming and trying to introduce these products. But still there's a lot of definition issue, the overall issue of how does it contribute to an investor, whether he is willing to take a lesser return. A long way globally, per se, India specifically in terms of sustainable financing or green bonds, yet to be achieved.
Sapan, thank you. You picked up on some very difficult questions about securing sufficient climate finance, what the sources of that finance should be, and what the form of that finance should be. Jorge, you earlier mentioned a very interesting provision in Article 2.1c of the Paris Agreement, which concerns flows of climate finance and ensuring that they're consistent with the objective of the Paris Agreement. What are the kinds of climate finance disputes that have arisen and might arise in future? And is there any role there for arbitration?
Yes, thanks, Nicola. Actually, I guess that it very much depends on the form of the finance, as Sapan was saying. And that form is not entirely unclear because it's a sector that follows boom and bust cycles. And we saw that it depends really very much on the price of carbon, and that price of carbon is about to change with the introduction of CBAMs. But let me start at the macro, then move at the micro, and then move at the meso. So at the macro level, very, very simply, as Sapan was saying, it's the expectations of climate finance are raising. So if you follow on average the climate finance that has been provided in 2019-2020, so there is a body that is following very closely. So we have $632 billion that were provided on average per year. Out of that, half and half were half public, half private, and 3/4 were domestic finance. Whether public or private, it was just investing in your own companies or in your own economy. And just 1/4 was international finance, so finance that went into countries. Of course, the focus of that finance geographically is very narrow. You have Western Europe, the United States, and to some extent South Pacific. But there are many areas that are being left out of that type of finance. We are expecting that to grow, at least the private part, and at least the adaptation part. But there are definitional issues. Just to give you an example, if you invest in transportation infrastructure, routes or highways, that can be used both for mitigation or for adaptation. So the definition aspect is not entirely clear. And that's a macro picture. That's a macro picture. So the short conclusion that I tend to gather from that macro picture is that most of this will be increasingly private finance for indirect investment and financial flows, sometimes portfolio investment flowing quickly. And that will force, to some extent, receiver countries to open up market access legally under trading services agreements or investment agreements. Under trading, I mean, both areas are not yet quite open. So that's what I see in the next 20 years. Now, if I move to the micro part, I mean, really very specifically. So Sapan was also mentioning the fact that we need contracts. For this, we used to have the contract, the famous ERPAs that were actually, exactly, they were ICC and London. And these ERPAs were used for the market mechanisms of Kyoto, the Clean Development Mechanism, the Joint Implementation Mechanism. I think they could be easily transposed just for the transactional side. That they could be easily transposed, and you could even come up with a template contract as these ERPAs were in the context of the International Emissions Trading Association. So you could find ways of, and that's as such an area of sort of a strategic area of development, I think, that you could develop a range of template contracts, not just for just purchase of emissions, but also for more complex financial instruments. And this is, let me give you just one example of something that is being under development, which is the so-called debt for climate swaps. Now, we studied together with Sapan in 2005 and 6, the International Finance Corporation, Harvard Law School. So I have good memories. So I remember learning about swaps together. So essentially, but these strange animals here are being proposed in the context of COVID rescue and recovery policies. Why is that? Because many developing nations, they face a trilemma. They have a limited budget. They don't know where to put it. So one way to deal with it would be that the creditors would tell a given developing nation to, instead of paying debt service, to actually convert that amount into local currency and put it into some form of green investment in the country. That would be about mitigation or adaptation, or who knows, loss and damage, but some green investment. Now that creates a number of complications, contractual complications and integrity complications, because if you do that, what happens if you have converted that and then the green part of the transaction is not delivering, Now, in some types of green transactions, if it's not delivering, well, it may be simpler to recall or to cancel and reconvert the system into the classic foreign debt. But in some other cases, it may not be that easy, because that would amount, again, to ask this developing country the money back at a time where the developing country may not have it again. So it's how you transform that and how you handle those disputes. Can those disputes be handled contractually? Can those disputes be handled by an arbitration tribunal, an ad hoc arbitration tribunal? If you look at it in hindsight, the clean development mechanism disputes, which were of the type that Catherine was mentioning earlier, was a rare type where you go to the country, the host country, you were expecting to get, 100 CERs or credits, and you get 70. So your investment is not paying off. Who do you sue? And you can sue the country by saying they interfered with the transaction, or you could actually sue the board, the climate change board, it was called the executive board, that assess the amount of credits that are owed to you and says that from an integrity perspective, you're owed fewer credits. So Kyoto had a specific dispute settlement mechanism there. We're not going to see that dispute settlement mechanism in this context, but it could be developed because of the more complex nature and the political aspect of the financial instrument, the debt climate swap. That's a micro. Then at the meso level, what am I expecting there? Well, I think that out of the many different possibilities for climate finance, what really is going to develop, and again, it's a guess by looking at practices. What is really going to develop is the area of integrity. And why is that? Well, because as Catherine was saying, in the early days, there was a lot of litigation about creating a cap and trade system and including, company A. And many companies were not happy to be included. And then the cap and trade system will expand. Now, why do I see the cap and trade systems expanding? Right now, you have something like 61 carbon pricing mechanisms. Those 61, half of them are cap and trade systems, half of them are taxes or carbon taxes. Now, why do I see them expanding? Because of the carbon border adjustment measures. So if you want to export to Europe soon, and perhaps to other countries as well, maybe the United States, maybe Japan, and there are different countries that are considering these border measures, these carbon or CBAMs. you may have to prove integrity. You may have to prove integrity. You may have to prove that you have a certain type of carbon pricing mechanism. That carbon pricing mechanism has to meet a number of criteria that are imposed extraterritorially. And that will create, and I'm working with one country, I cannot say which one, but I'm working with one country with that type of transition. That may create a lot of pressure for the country to introduce a cap and trade system that is meeting a number of integrity criteria that are verifiable. And that, again, raises issues of verification that are technical issues that require standardization. But this, I think, CBAMs are going to drive more and more the creation of cap and trade trading mechanisms. And because these trading mechanisms will require some measure of verification that is standardized at the meso level, not at the micro or at the macro, but at the meso level, I think we will need guidelines in the same way as we need template contracts. We will need guidelines that are acceptable, even if they're not binding around the world, but we will need guidance that is acceptable widely. And that is the forum in which this flow into carbon credits, this financial flow into carbon credits will be acceptable and recognizable.
Okay, thank you so much for those remarks. I'm conscious of time and the fact that we wanted to fit in a few questions from the audience before we finish. And so I'll conclude that extremely interesting and insightful discussion by the panelists and turn to one question I think we do have time for. I'll ask Gopal, Nonit and Sapan for you to perhaps give some brief responses to this question. Is there a tension between the natural desire of many parties for their disputes to be resolved in private by a mechanism such as arbitration and the possible public interest for environmental disputes to be heard and to have the decisions of those disputes made public? So is there a tension there and how can it be resolved? At what point is arbitration suitable? Gopal, perhaps we'll start with you. Please go ahead.
Sorry, I think it's a question of degree. There can be degrees of, I wouldn't use the word absolute at all, but I would say strong degree, which have a public law and a public policy element of such a compelling nature that they're not suitable to be dealt with by arbitration. I'll give you the best example. The best example is the Bhopal gas tragedy. Take that case where people died. Could that have been settled by the government of India by arbitration? Or could even, shall we say, the legal representatives of the people who perished actually have settled it in arbitration with Union Carbide? That contract would have been illegal. If there was an agreement to arbitrate such a dispute, it would have been illegal, which is why in that case, the government of India through Parliament, it enacted a law in the capacity as parens patriae for the purpose of acting on behalf of the victims. So there can be cases of damage of such a nature that it entrenches upon either serious tort or strict liability, or can even be a very stark criminal offense, in which event it falls out of the boundaries of arbitrability. But short of that, the rest is arbitrable. Short of that, the rest actually, now that's what the Supreme Court has said, the rest is arbitrable.
Thank you, Gopal. Nonit, some brief views from you, please.
I think I completely agree with what Mr. Subramanian just mentioned. And I think the kind of inequalities that you have in this country, I don't think at this stage at least that arbitration would be the right method to deal with the kind of cases that you mentioned. So I think the time we reach that level of equality and maturity as a jurisdiction, I think what we have makes sense for us, at least for the next few years.
Thank you, Navneet. And
Well, I'll add one more thing here is that there's also a lack of understanding with the judiciary in the private disputes. And that is across jurisdictions, because it's a very new area of law. And arbitrator with some sort of an experience in this, which is developing at universities, at various forums, could actually contribute to how it will progress, rather than judges deciding across the world without any basic knowledge of what the law is. So there's also a need that the expert arbitrators are available to help evolve the law.
Thank you, Stapan. We've reached the end of our allotted time today, and before I hand over to Niti, I'd like to thank once again our panelists and for Constantine as well for all of your excellent contributions and for such an interesting discussion. It has been my pleasure to speak with you today. Thank you also to the audience for your attention, for sticking with us until the end, for your questions, and to the MCIA for your collaboration in organising and hosting this event. Niti, over to you.
Thank you, Nicola. Let me begin by thanking all the panelists for their insightful and interesting comments. I must say, we didn't realize how the time just flew by. In the last 5 years of its existence, MCIA has made some significant progress, and we continue to lead our initiative to bring innovation to arbitration in India, to discuss latest developments, and to remain ahead of the curve. Be it by promoting green arbitration, by introducing plug-and-play model of arbitration hearings, or introducing technology to effectively administer disputes. We also launched the MCIA User Council in 10 different sectors, whereby we are connecting individuals from across the globe to build a robust network to promote effective dispute resolution. In our latest effort in bringing international best practices to India, and to talk about latest developments in the field of arbitration, it is this effort, which is to launch the India Climate Change and Environmental Disputes Day in collaboration with Three Crowns LLP. We are all well aware that climate change is a very important and pressing issue, and that we all need to address it on an urgent basis. Today, we heard from our esteemed panelists that how climate change is more than environment. It is about peace and stability, and that is where dispute resolution and specifically arbitration will also have a significant role to play. We at MCIA, in collaboration with Three Crowns, will continue to engage with the stakeholders to talk about climate change, to talk about environmental disputes, to talk about different kinds of issues that may arise, and we look forward to your continued support. Let me assure you all, this is not just one of the events, but a humble beginning to discuss this further over the next few months and years. We will look forward to your support and suggestions for this important topic and otherwise. I once again thank all the panelists, Constantine for his opening remarks, our supporting organizations, to Ms. Nicola Schwab from World Economic Forum for her special remarks, which you can hear on MCIA LinkedIn page, and surely last but not the least, Three Crowns for their collaboration and support. Thank you once again, and have a very good evening.
Thank you, everyone.
Thank you. Bye-bye.
Thank you. Thank you very much. Thank you. Bye.